May I please,
Yes,
with the concern of the other side, I'd like to mention item number 14 to 16, Lordship. In this case, we will file an addition, we'll file an affidavit in reply, Lordship. So kindly the matter will be taken up on
when?
16th of February, Lordship.
Straight for by learned counsel
Senior counsel, Mr. D. Saikia will appear in this case, Lordship.
for the petitioner. No, not opposed by the other side.
14th to 16th.
List
14th.
again on
16th of February,
16th of February 2026. The respondents, the petitioners shall file their affidavit in reply
Yes, Your Lordship.
as undertaken by them
Yes, sir.
by the next date.
Much
Obliged, Lordship.
Meet please, your lordship. My lord, I beg to mention item number 7 to 11, my lord. Basically, it is a joint prayer, my lord. I am just told that Mr. Nabam, who is appearing for the government, he has also some personal difficulty today, my lord. So, my lord, may I pray that the matter may be taken up on 18th of this month, my lord. Because Mr. Kyle is appearing on behalf of the central government. He expressed some urgency, my lord.
Your
Yes,
Lordship,
yes.
we have not filed our counter affidavit, Your Lordship.
18th,
You file
Yes, Your
by
Lordship.
18?
yes, my lord.
IAS for what?
For vacating of stay, my lord, filed by the GST authorities.
Any objection filed by the other side?
We have filed our objection.
You have filed objection.
Yes.
Okay.
I mean, for the petitioner, my lord.
Okay. As on a joint prayer made by the parties, let the matter be listed on 18th of December 2025
Right.
in the admission column.
Yes, ma'am. Interim may kindly be continued.
Interim order passed earlier shall continue.
My lord.
Parties are also at liberty to exchange further pleadings.
I'm deeply obliged.
Yes, Your Lordship.
Your Lordship, I would like to mention item number 12.
Yes.
Your Lordship, due to due to some unavoidable domestic issue,
Give me item 12.
the leading counsel is out of station.
Is somebody here to help you? Where is the grade 4? Attendant. You keep somebody here to help you. What are you saying?
The leading counsel is out of station, Your Lordship.
Who is the leading counsel?
Adam Tatak.
So when do you want it?
This matter may be listed after 3 weeks, Your Lordship.
Are you going to file your reply? Please write down Mr. Adam Tatak, learned counsel, who is said to be the lead counsel, is out of station. Who is said to be the lead counsel for the petitioners is said to be out of station. So I want to pray made on his behalf and not objected by the other side. Matter stands adjourned for 3 weeks. The petitioner shall file their petitioners to file their reply affidavit in the meantime. You so advised. All right.
Obliged, Your Lordship.
Item number 1.
May I please, Lordship?
Yes.
Lordship, regarding the maintainability of this present writ petition, Lordship, I have a 2 judgment. One is of
One is you have already given me yesterday.
yes, Election Commission of India versus Ashok Kumar Sinha.
And another one.
Another one is Leela Sharma, that is 2019 1 GLT
Where is the copy?
302. I've already copied.
Which paragraph?
Yes, Lordship. Lordship, page number 310, 45. Para 45.
Read.
Thus, from the careful and conjoint analysis of the judgment of Supreme Court as above, what comes to the fore is that ordinarily a a change challenging to an election has to be by the way of election petition as provided under the statute. However, neither Article 329 nor Article 343 or totally outside judicial review from the election process, so also to provide provision of section 129B of Panchayati Raj Act. If the decision of the returning officer or the election officer is found to be erroneous, which obstructs the democratic process or which creates hurdles in the free and flow election of election, or which creates a situation where free and fair election is hampered, High Court under Article 226 will certainly interfere and the remedy the situation to further the cause of election process. But while doing so, the writ court would be extremely circumspect and slow in invoking the power of judicial review. It is only when a foolproof case is made out in a extraordinary circumstances, High Court would invoke the writ jurisdiction under Article 226 of Constitution of India. Lordship.
Okay.
So Lordship, here in this case, prima facie there is a malafide and arbitrariness in the part of the returning officer by rejecting the nomination of the present writ petitioner. Lordship, here my case is that, very simple case, Lordship. My name is Gichik Yasa, YASA, in the Aadhaar card, in the PAN card, issued by the government of India. My name has been written as Gichik Yasa, YASA, but the respondent authority, that is the election Panchayati Raj, in the electoral roll, the authority has written my name is Gichik Yasap, YASSAP. That is the only discrepancies. And because of that reason, even the reason has not been given to me, despite my furnishing and representation, despite of filing RTI, despite of seeking the reason for rejection, they have not given the reason of rejection, but they have said that because of discrepancies in your name, we have rejected your nomination. And the reason is that they have written my name in serial number 144 of electoral roll as Gichik Yasap instead of Yasa. That is the only reason they have rejected. So they are restraining me from participating in the election process, Lordship. Because of that, I have been barred from contesting election in this particular GP constituency. And Lordship, as per the Panchayat election manual, only when the nature of rejection is sustainable in character, then the rejection has to be done. And what are the sustainable character? It has been already provided. If my name is not in the electoral roll, if I am not a citizen of India, if I am a minor, in hyper-technical reason, my nomination cannot be rejected arbitrarily. That is my grievances.
All right.
So Lordship, election is not yet conducted. It will be held tomorrow. Lordship, my submission,
Not tomorrow.
so,
15, I think.
sorry, 15 on Monday. Time is there, Lordship. So my submission before this honorable court is that instruction may be short, that what is the reason for rejection? Had the ground of rejection of my candidature is sustainable in character, I may not be entitled. But if the ground of rejection is only and only because of the mistake done by the respondent authority by typing my name as Gichik Yasap instead of Yasa, I may be allowed to contest in the election, Lordship.
Okay.
That is the only case.
One thing you tell me, why did you come here after some time?
Lordship, I was waiting for, yes, Lordship,
Waiting.
yes, Lordship, I have,
Now you are waiting for the polling.
no, Lordship, I have filed an RTI application, I have filed a representation seeking for the ground of rejection, but
That was in November 25th.
Lordship, it's been On 26 only my scrutiny has been rejected. And I have been visiting the office of returning officer
26th of which date, of which month?
26 November.
November.
Yes, Lordship. 26 November is the date of rejection. And since then, I am running after pillar to post, seeking the ground of rejection, but they are,
Could not find your way to the High Court.
Lordship,
Even from pillar to post, you could not find the way to the High Court.
Lordship,
Finally, on the last moment, you found the way.
Lordship. Therefore,
Tomorrow is what, Saturday, day after tomorrow is Sunday.
Lordship, they can,
What instructions can we have? Court is not sitting on Saturday, Sunday.
Lordship, but instruction to the effect that what is the ground of rejection of the petitioner? If it
But
is,
you already know, you said the ground of
Yes,
rejection is
that-
because of the spelling,
yes,
there's
but
some spelling mistake.
Lordship, that is not the substantial character for rejection of my nomination.
Okay,
Lordship.
let's see what we say.
Lordship, improper rejections can only be filed through election petitions. The citation which he has relied, that is Leela Sharma case, I'm also relying that judgment, Your Lordship.
Mm.
Here, in this case, the Honorable Court addressed batch of petitions challenging rejections of nominations, Your Lordship. That is reported,
What is that?
Lordship.
What is the judgment you're giving me?
Judgment, Lordship, 2019 1 GLT,
Which one?
that the judgment which he has relied.
He has
just now.
already given me, how many copies do I require? I
Your
have to read
Lordship.
only one copy, na?
Yes,
Only
Your
two copies.
Mm.
Lisa Sharma, he has already given me.
Lordship. Here, the writ petition was dismissed, Your Lordship. The petition was dismissed, Your Lordship.
Correct, it
It
was
was-
dismissed.
Yes, Your Lordship. And while dismissing, the High Court has, while rendering the decisions, Your Lordship, the High Court has relied on established several Supreme Court precedents, Your Lordship. That I would like to rely para number 38, Your Lordship. I have plagued para 38, that is in page number 8 of,
Just read 38.
yes, Your Lordship. Referring to the language of Article 329B, Supreme Court held that by,
38.1.
oh, sorry, Your Lordship, 38. Coming to the second questions, bar under Article 243O of the Constitution and Section 129B of the Panchayat Act, we may once again revert back to the decisions in NP Ponuswamy Supra, which is the leading case on the subject. In that case, Constitution Bench of the Supreme Court held that any matter which has the effect of vitiating an election should be brought up only at the appropriate stage in the appropriate manner before a special tribunal and should not be brought up at intermediate stage before the court. Under the election law, the only significance which rejections of nomination paper has considered in the fact that it can be used as a ground to call the election in questions in an election petition. 38.1, Your Lordship. Referring to the language of Article 329B, Supreme Court held that by necessary implications, such grounds calling the elections in questions cannot be urged in any other manner at any other stage and before any other court, permitting parallel proceeding, that is assembling an election petition before the election tribunal and invoking power of judicial review would lead to anomalies which the constitutions could not have contemplated. In that case, Supreme Court also noted that Madras High Court and seven other high courts had held that remedy of Article 226 would not be available regarding improper rejections of nomination papers. Supreme Courts affirmed the said view by holding it to be the correct view. Then, Your Lordship, para 39, Your Lordship. A letter, Constitution Bench of the Supreme Court in Mohinder Singh Gill's case took a slightly different approach and observed that bar of interference by the courts would not exclude judicial review if it is for the furtherance of elections. If the Election Commission acts in a manner which prevents free and fair elections, courts' judicial review of such decisions will facilitate the flow, not stop the stream. Elections, wide or narrow, be its connotations, means choice from a possible plurality, and if that concept is crippled by the Election Commissions Act, it holds no elections at all. Immunity under Article 329B of the Constitution is conferred only if the act impeached is done for apparent object of furthering a free and fair elections, and the protective armor drops down if the act's challenge is either unrelated to or towards or tends the course of elections, Your Lordship. And next, para 40, Your Lordship. In Bodula Krishnaya Supra, which is a case relating to Panchayat elections in the state of Andhra Pradesh, Supreme Court observed that once the election process has been set in motion, though High Court may entertain a writ petitions, it would not be justified in interfering with the election process by giving directions to the election officer to stall the proceedings or to conduct the election process appraise. Then next para, Your Lordship, para 41. The issue relating to inference by the High Court in the election process under Article 226 of the Constitutions continued to raise legal and constitutional questions. After surveying the entire law on the subject, a three-judge bench of the Supreme Court in the election case of India, Election Commission of India versus Ashok Kumar, Supra, summed up the positions. Though entire conclusions may not be relevant for the purpose of the present adjudications, what is relevant to note is that the expression elections has received wide interpretation so as to include all steps and entire proceedings commencing from the date of publications of notifications of the elections till the date of declarations of result. If an election is to be called in questions, which questioning may have the effect of interrupting, obstructing, or protracting the election proceeding in any manner invoking judicial remedy has to be postponed till after the completion of election proceedings in elections. Second legal positions which has been called out is that any decision sought and rendered will not amount to calling in questions and elections if it subserves the progress of the elections and facilitate completions of the elections. Anything done towards completing or in furtherance of the election proceedings cannot be described as questioning elections. In the circumstances, action taken or orders issued by the election commissions would be open to judicial review on the well-settled parameters, such as malafide or arbitrary exercise of power or acting in breach of law. Therefore, without interrupting, obstructing, or delaying the progress of the election proceedings, judicial intervention is available if assistance of the court is sought for merely to correct or smoothen the progress of the election proceedings or to remove obstacles. However, while doing so, the court must be very circumspect and act with caution. Considering the very nature of the things, the court would act with reluctance and shall not act except on a clear and strong case for its intervention, having been made out by raising the plea with particulars and precisions and supporting the same by necessary material, Lordship. Now 42, Your Lordship, para 42. In Manda Jagannath Supra, on which heavy reliance has been placed by Mr. Bora, High Court had entertained a writ petition and set aside the decisions of the returning officer, treating the candidates of the respondent as an independent candidate and not as a candidate set up by the political party, Telangana Rashtra Samiti. While setting aside such decisions of the High Court, Supreme Court held that whether returning officer was justified in rejecting the nominations of the respondent or not was not a matter for the High Court to decide in exercise of its writ jurisdictions. This issue should be agitated by the aggrieved party in the election petitions only. While acknowledging the erroneous decisions of the returning officers are amenable to corrections in writ jurisdictions, it was clarified that erroneous should have the effect of interfering with the free flow of the scheduled elections or hinder the progress of the elections, which is paramount consideration.
Okay, madam, I've read the
Lordship.
judgment.
Lordship.
Anything else you want to submit?
So, Your Lordship, this petition is not maintainable. Here in the Lila Sharma case also, direction was given to the petitioners to approach before the election tribunal for any improper rejections of the nominations. So this petition may be disposed in threshold, Your Lordship.
All right. Anything?
Lordship, apart from this legal, just on the pace of the records, Lordship.
Hmm.
Because Monday, election is on
Hmm.
Monday, Lordship. Now, the settled law, as per what I understood is the Lordship, there cannot be any order which will amount to hindrance to the election process, Lordship.
Hmm.
So, the issue before us is concerned, Lordship. To decide this, whether it has been rightly or wrongly rejected, Lordship. For that, Lordship, there has to be, Lordship, instruction has to come from the government also. Because at this stage, we can't say whether it has been properly rejected or illegally rejected, Lordship. For interference of this Honorable Court also, the petitioner has to prima facie, Lordship. It must be apparent on the face of the records that illegally it has been rejected. Under this extraordinary circumstances, also this Honorable Court interfere, Lordship. That what I understood is lawly done by the various courts, Lordship. On the face of the records, Lordship will find page 23, Lordship.
Page?
Page 23 of the writ petition. This is the scheduled tribe certificate of the writ petitioner.
Hmm.
Lordship will find name is Gichik Yasa,
Hmm.
father's name is Pisa Tali, and mother's name is Pisa Yaku. Then Lordship kindly come to the page 25, Lordship.
Hmm.
Page 25, Lordship.
Hmm.
This is the Lordship.
What certificate?
Birth certificate, Lordship.
Hmm.
Lordship will find the name of the mother is Sope Yaku, and name of the father is Sope Tali, Lordship.
Hmm.
This variation also is there, Lordship. And also in the Lordship, in certificate, if Lordship see the birth date, Lordship, age comes to 46 years, Lordship. But in some certificate, it has been stated, Lordship, is age around 40 years. That deviation may be there, Lordship.
Hmm.
But what I'm pointing out is, Lordship, apparently there's something wrong is there, Lordship, on the records itself, Lordship. And we don't know on what exact ground, Lordship, the petitioner's nomination has been rejected, Lordship. So, Monday, Lordship, is two, Lordship.
Hmm.
So, under this circumstance, Lordship, my prayer is that, Lordship, Lordship, this Honorable Court may not interfere. That's all.
All
May,
right.
may I please, Lordship? May I please,
I've heard you, Mr. Counsel. Anything you want to add?
Lordship? Lordship, page number 65, annexure 9. Lordship, this is the relevant portion of manual wherein in which case rejection of nominations has to be made by the returning officer. Lordship, in page number 65 down below, ground for second paragraph, ground for rejection of nomination paper. Lordship, these are only the prescribed ground where a nomination of a candidate has to be rejected. If there is any other ground, there cannot be rejection, Lordship. The returning officer shall decide all objection which may be made to any nomination and may either on such objection of his own motion, after such summary inquiry, if any, as he thinks necessary, reject any nomination on any of the following grounds. That number 1A, the candidate is disqualified for being chosen for file the seat by or under any act, that the proposer is not a voter of the constituency concerned, that there has been a failure to comply with the provision of rules 5 and 6, and the signature of the candidate or the proposer or the nomination paper is not genuine. Lordship, here in this case, Lordship, may I take the Lordship to page number 72? That is in the additional affidavit, Lordship.
Mr. Counsel, I think I've heard you.
Lordship,
I'm disposing it up right now.
Lordship, Lordship.
Heard, Mr. You are Mr.
T Taba,
T. Tapak,
Taba,
T. Taba,
Lordship.
learned counsel for the petitioner. Who submits that the petitioner is aggrieved with the rejection of her nomination for the post of Gram Panchayat member of 8/77/2-Roman 2 constituency under 8 Tali West Zila Parishad constituency in the district of Kradadi, Arunachal Pradesh. From the People's Party of Arunachal. So he submits that the petitioner, upon perusing the list of validly nominated candidates published by the respondent number 5 on 26/11/2025, was surprised to find her nomination her name not amongst the enlisted nominees. So upon making an inquiry, she has come to learn that her nomination has been rejected due to a mismatch of her name in her electoral roll submitted by her. So although the name of the petitioner is Gichik Yasa,
Yes, Lordship.
the same has been reflected as Gichik Yasap. Stop the Learned Counsel submits that the chapter Roman 4 rule three submits that the returning officer, rule 3 of the Panchayat election handbook for returning officer 2025
Lordship.
provides that the returning officer shall not reject any nomination paper on the ground of any defect which is not of substantial nature. So further, referring to the second clause of Rule 2 of Chapter 4 of the handbook, the Learned Counsel submits that the grounds for rejection of nomination papers have been specifically provided therein. And therefore, without specifying any particular reason, the returning officer could not have omitted the name of the petitioner from the list of validly nominated candidates published on 26/11/2025. Stop the Learned Counsel therefore submits that the returning officer should be directed to accept the nomination paper of the petitioner so that the petitioner can participate in the election process. Since the voting is to happen on 15th of December 2025. By giving suitable direction to the state authority. Stop the Learned Council submits that the High Court, in exercise of its powers under Article 226 of the Constitution of India, can interfere with such a decision of the returning officer since the action of the returning officer right, like interfere with the action of returning officer on grounds of malefied and or arbitrary exercise of power. Stop in support of his submission, the Learned Council relies upon the case of Election Commission of India versus Ashok Kumar and others. 2000, Volume 8, SCC 216. And Leela Sharma and others versus State of Assam and others. 2019, 1 GLT 302. Next para, Miss
Anju.
Anju, Learned Standing Counsel for the State Election Commission, on the other hand, submits that the writ petition is not maintainable in view of the fact that as a remedy provided for such kind of grievance through filing of election petition. Which is to be adjudicated by the election tribunal constituted by the state government in terms of section 123 bracket 3 of the Arunachal Pradesh Panchayati Raj Act 1997. Bracket Act of 1997. Close bracket, full stop. She submits that section 122 of the State Act clearly bars jurisdiction of courts, and likewise Article 243 O within bracket small b of the Constitution of India also specifically bars the jurisdiction of the court against an order in it, jurisdiction of the court against an order passed by the returning officer rejecting the nomination paper. To stop, she also submits that she too relies upon the case of Leela Sharma and others, Supra, wherein the coordinate bench of this court, after going through various decisions of the apex court, declined to entertain the writ petitions. Stop referring to the said judgment, comma, the learned standing council submits that the petitioners therein had also approached the High Court on the grounds of rejection of their nomination papers for one reason or the other by the returning officer. On facts, she submits that the returning officer either found the nomination papers to be incomplete for want of Bakijat clearance certificate, or the nominee having held the office of prophet, or the candidate having failed to choose any particular symbol of an independent candidate. Similarly, in the instant case, although it may so appear that it is the mismatch on the name of the petitioner in the electoral roll submitted by her. But as contended by the learned counsel for the petitioner, but it could very well be for other reasons which have been found to be substantial in nature by the returning officer. Stop. She submits that since polling is due on 15th of December, there is otherwise no time at this stage even to obtain instructions, even if the same was required to be obtained. Stop. She submits that this court also had taken up a similar issue on 5/12/2025, that is WPC number 563 of 2025, open bracket, Nabam Pada versus Chief Secretary and 3 others, close bracket. And upon considering the grievance of the petitioner, which is similar to the present one, this court had declined to interfere and disposed of and dismissed the writ petition at the motion stage itself. Stop. She therefore submits that a similar order has to be maybe passed in the present case as well, in view of the specific bar for entertaining such kind of grievance by the courts. Next para, Mr. S. Tapin, learned senior government advocate, also adopts the argument made by learned standing counsel for the State Election Commission and submits that not only there appears to be discrepancy in the name of the petitioner, but also in the name of our parents as can be seen from the scheduled tribe certificate and birth certificate annexed to the writ petition. Stop further, there is also some discrepancy in the date of birth as well. Stop, he also submits that whatever the reason may have been, since there is a bar for entertainment of a case of such nature by courts, the instant writ petition may not be entertained by this court, and the petitioner may be relegated to the remedy available in accordance with law. Stop, upon hearing the learned counsels for the parties and upon perusal of the materials available, including the authorities relied upon, this court finds that there is no scope for this court to entertain the instant writ petition in view of the specific bar provided. Under section 122 of the Act of 1997, read with Article 243 O small b of the Constitution of India. The apex court in Election Commission of India versus Ashok Kumar and others, Supra, also held that the courts cannot interrupt, obstruct, or protect the election proceedings. But it would be open for judicial review on grounds of malified or arbitrary exercise of power. Now, in the instant case, whether the action of the returning officer can be termed as a malified or arbitrary exercise of power is a question which have to be determined. Which cannot be determined on the basis of the materials available on record. Moreover, as already observed, elections are to be held on 15th of December, and the writ petition had been filed only yesterday. That is, what is the date? 11th of December 2025.
Lordship, it was filed on 10th.
Filed on 10th of 2025 and listed on 11th of December 2025. This court finds that there is no scope even for requiring the respondent councils to seek instructions in the matter. Accordingly, this court declines to entertain the writ petition by giving liberty to the petitioner to approach the election tribunal as and when the same is constituted with the grievances projected by her. With the above observation and directions, the writ petition stands disposed of.
Lordship,
Okay.
may I? Lordship, in this particular constituency, only one candidate is there. As such, there will be no election, Lordship. He will become uncontested.
Anyway, you file your remedy thing, so it'll have to be seen. We can't go into that aspect also, no?
Lordship.
Obliged.
Deeply obliged.
Item number 2.
Mayor Lordship,
Yes.
this this is the second round of writ petition, Lordship. Basically, this petitioner is a political interpreter known as Kotaki, who is attached with the Deputy Commissioner Office. This practice is a British legacy since then. And as per the recruitment rule, Lordship, this promotional post of Kotaki is political assistant. And he has been serving as a political assistant, not as a political assistant, as a political interpreter, PI. And his seniority list is page number 22, annexure number 3. Page number 22, annexure number 3.
Where are you? Serial
Of the WFI. Page number 22, annexure number 3.
Serial number?
Serial number, one of the PI is by name Lumane Melo.
1.
Yes, 1.
Amud Nopi.
Yes, Lumane Melo. PI grade 1.
Okay.
Yes, and
Mane Melo. Okay.
yes,
This is the
Lumane Melo.
petitioner.
And yes,
Then?
my previous senior was earlier my senior was Amud Nopi. It is a PA is political assistant. That is a
You are
promotional.
interpreter.
Yes,
You are political interpreter.
yes, political interpreter.
Next promotion is political
Political assistant.
assistant.
Yes.
What is the criteria?
Criteria is Lordship, may I this kindly see. This criteria is annexed in page number 24. Annexure number this annexure number 5. This is the second para. This is the RR recruitment rule
Please read.
framed by the government. This is sources of appointment. Appointment to the cadre of the political assistant will be made from the serving interpreter, grade 1. I am grade 1. And area superintendent belonging to Nefa tribe. I am Nefa tribe on the agency level, taking due care that district and tribe are duly represented in the service as far as possible on the basis of the merit cum seniority on the basis of recommendation of the DPC. Accordingly, what is the criteria? Procedure for appointment is next, rule 3. Rule 3, this sub-rule 3, provided that this provided it, how it is political assistant, provided that no person shall be recommended under the sub-rule 1, nor the DPC shall select any such person unless the recommending authority and the DPC, as the case may be, taken into consideration of the following aspect of the candidate. Like there is no educational qualification is this prescribed here. This personality and character is criteria. Track energy, general intelligence, integrity, influence on his own tribe and on other tribe. Service can more profitably be utilized by the appointment to the cadre of the political assistant. Physical fitness, ability, any special weightage for more backward or sensitive area with NEPA tribe. This is the criteria. But my case is, Lordship, accordingly, during when my senior was there was a seniority dispute. But in this case, I have this, in the previous writ petition, I filed the previous writ petition on the ground that although my this promotion was due, I have not been promoted. But during the pendency of that previous writ petition, my senior died. So I became senior. So accordingly, as per the Honorable Court direction, kindly see page number 32 is the previous writ petition direction. Page number 32. This is annexure 10. An operative portion, I'm reading by operative portion, page number 32. This para 5, considering the consensus at bar, as well as the considering the that of the respondent number 4. The present writ petition stands disposed of directing the writ petition to file a fresh representation before the Deputy Commissioner Ying Kyung. That is the respondent number 3 for the
Okay.
consideration of the case.
Have you filed representation?
Yes, accordingly, Lordship.
Was it considered?
Yes,
Where?
they dispose the representation, Lord.
Where is that?
This representation is page number 41 of my WP and annexure 14.
Rejected?
Yes, rejected, saying that I do not have any educational qualification. Whereas rule doesn't provide that there should be any educational qualification. Kindly see. This is operative portion is, I am reading from this second paragraph, this page number 42. And
Yes.
whereas after aforesaid fresh representation that at 4/12/2024 and 6/12/2024 submitted by the petitioner Lomanemel in compliance with the side order dated 6/8/2024 passed by the Honorable Court were re-examined vis-a-vis the RR of the political assistance issued by the government notification number such and such and office memorandum such and such, and it is subsequent correction of such and such, an office report like seniority list of PI, including the educational qualification of Sri Lumane Melo, PI grade 1 from this office record. It is established that the educational qualification of Lumane Melo is that he has read up to class 3. This is the issue, crux of the case. Whereas rule doesn't prescribe for PI, there should be any educational qualification. There is any other qualification has been prescribed for the PI. So considering the above facts and circumstances of the case and the opinion that applicant Sri Lumane Melo PI grade 1 of this office is not eligible for promotion to the post of political assistant for want of minimum prescribed educational qualification as notified by the, there is a OM notification, Lordship, saying that for appointment of Group B post, Group A or Group B post, there should be a minimum graduation should be the minimum eligibility criteria. That is the
Minimum what? Graduation?
graduation.
Where is that?
Page number 43. This is not RR. This is a general administrative order from the administrative reform. Page number 43. This type copy is page number 46, annexure number 15.
Anyway, we'll issue notice at this stage.
Yes, I am praying that this post may not be filled up.
Mr. Tapin?
Lordship, notice can be issued, but otherwise also, Lordship. There's already office memorandum of the said government, Lordship, regarding the.
That is a general one.
But
That's a general one.
But-
And what about these rules for appointment of political assistant?
But it's silence on the education qualification, Lordship. When Lordship rule is silence on the education qualifications, by way of Lordship office memorandum or other order, education qualification.
No, this is a kind of, like a kind of a one of a kind of appointment.
No.
This was the one of a kind appointment. You see, political assistant, political interpreter.
Yes, political interpreter,
Ah.
prescribed. Who
This
assists
was,
the deputy
this was
commissioner.
prevalent in most of the states
Yes,
earlier.
Lawsuit earlier.
There
So this is still
legal-
prevalent here.
Yes, yes,
And you have referred to this NEFA thing.
Yes,
So we are no longer in NEFA era now.
Yes.
We are a state now.
yes.
So why should you still insist that there is no educational qualification?
Yes.
Isn't it? Had it been those NEFA times, then it's a different thing. But now things have really developed now.
Lawsuit.
Anyway, that will be examined. We'll see.
Page number 26, that is, again, it was amended, kindly see.
Mm.
Kindly
You have
page
been,
number 26,
No, you have been working since when?
I have been 1997,
Sorry?
1997, I have been.
97.
Yes.
Okay. Page
Not 97, 93.
93.
I have been, page number, annexure 1, it's my appointment order.
Annexure 1.
Yes,
No, you were saying some amendment.
yes.
What is that amendment?
Kindly see, amendment is not exactly amendment, the supplement is page number 26, lecture number 6. Page number 26, kindly see. Issued by the chief secretary. The governor of Andhra Pradesh is status attest, pleased to order that the present rank and status attested to the political assistant shall continue to be Group B gazetted. All the pay structure attached to the post had fallen under Group C. This salary is under Group C and the status will be under Group B. It is the special category notified by the chief secretary. He is a Group C category. As per as this.
That's okay.
elements.
They're not on that. They're saying that your qualification, you're not qualified because
Qualification
only
is
class
not
3.
required. The qualification, this procedure for appointment is,
you should also say that even politicians, MLAs are also not required to have any such qualification.
Yes.
There's no prescription.
no prescribed qualification.
Is there any prescription?
No.
Only
Yeah.
graduates can contest election.
Yeah.
Then,
But so
so
far
the name itself says political assistant, political interpreter.
Lawsuit.
So the requirements are a bit different, you see, unlike other jobs. It has been already been seen, personality, character, integrity,
Influence.
general intelligence, integrity, influence to the tribe. Service can be utilized, physical fitness, executive ability, all these things, you see, their requirement is something else. What is your duty otherwise? Do you write and all that?
I'm assisting this to manage with the rural people who is not well well versed with the local language. Wherever is
Of course,
the deputy commissioner generally come from
being educated would be a plus point.
yes, being educated will be.
Lawsuit, this rule is of 1967 lawsuit. If lawsuit see the page 26 lawsuit, if lawsuit see the page 26 lawsuit. Rule is of 1967, but
No, Mr. Tapin,
lawsuit.
we're not disposing of the case now.
Now,
So
the-
we'll issue notice.
because this office memorandum up to 19 lawsuit,
Mm.
whether it can supplement the recruitment rule or not lawsuit. When lawsuit education qualification is not prescribed in the recruitment rule, this issue has been always settled by the Sonora Court by a division bench of the Sonora Court lawsuit. It can substitute on the same issue lawsuit.
And that will be seen at the appropriate time.
Lawsuit.
But I'm inclined to grieve some interim order.
Law.
But Mr. P. Tapak, learned counsel for the petitioner, who submits that this is the second time the petition is before this court. Of the earlier writ petition filed by the petitioner being WPC number 575 of 2023 was disposed of by order dated 6/8/2024 by directing the petitioner to file a representation before the authority concerned for consideration of his promotion to the post of political assistant. Since he was the senior most political interpreter after the next person who was senior to him had expired. So a person there too. The petitioner submitted his representation, but the same was rejected. By order dated 14/7/2025. Stop. As such, the petition is again before this court. Next para. Learned counsel for the petitioner submits that the ground for rejection, the representation of the petitioner is that he has read only up to class 3, whereas the government office memorandums quoted in the impugn order provides for minimum qualification of graduation. Of the learned counsel submits that the grounds given for rejecting the representation is not sustainable. In view of the fact that the rules for appointment of the cadre of political assistant as issued by the Government of India in the erstwhile Northeast Frontier Agency does not prescribe for any educational qualification. Stop. Therefore, having regard to the services rendered by the petitioner ever since he was appointed in the year 1993, he should be considered for promotion to the next higher post of political assistant. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr. S. Tapin, learned senior government advocate, accepts notice on behalf of all the respondents.
1 to 3 notes, all the rest.
As such, no formal notice is not required. Petitioner shall furnish requisite copies of the writ petition to him within 3 days. Next para, having regard to the projection made by the petitioner, it is provided here in that till the next returnable date, the respondent authorities shall not fill up the post of political assistant. Where is the post?
Post is at Yingkiong. Under the
Joseph,
Commissioner Yingkiong.
Basically, Lordship, in promotion matter, interim may not be considered because it will hamper the public interest, Lordship. Until unless on pace, Lordship,
We are balancing that now. We are not just passing order like that. His interest also we're looking into it. He's the senior most.
that I understood, Lordship. But apparently, Lordship, law is something else, Lordship. Here, Lordship, as I submitted, Lordship.
You see, you take your instructions.
2019, Lordship, a general Lordship, office member has issued, Lordship.
Okay, cancel that last part. Having regard to the projection made by the petitioner, it is provided herein that the prayer for interim shall be considered on the next returnable date. Stop. However, status quo as on today shall be maintained. List again on so and so. Give that date. 19th of January 2026.
Lordship.
Item number 3.
Yes.
The petitioners who are working as mob charge assistant operator in the Department of Power was retired on 29/2/2024. Thereafter, Your Lordship, when he went to the office of the executive engineer, Your Lordship, to Your Lordship pursue his pension papers, Your Lordship. The Lordship department has handed over him a duly filled up challan, Your Lordship. Whereby he was directed to pay an amount of rupees 4,64,348 rupees.
Has he paid?
No, Your Lordship.
Not yet paid.
No, it cannot be fair, Your Lordship. Because there was nothing on the petitioner's fall, Your Lordship. 2 times the sublease
What is that 4 lakhs for?
being the excess withdrawal, Your Lordship,
Withdrawal from what?
from the department, Your Lordship.
How did you withdraw that from the department?
The department has given me it, Your Lordship. They had prepared, Your Lordship, after the completion of 30 years in the service, I have, Your Lordship, the department.
No, is it a wrong fixation of pay?
Yes, Your Lordship.
Oh,
Wrong fixation of pay.
otherwise I was thinking just like that, you're withdrawing the money from the
No, no, Your
department.
Lordship, they have wrongly fixed the scale pay.
Okay,
So,
where is the challan?
Your Lordship, kindly see
Page 56.
55 on what, Your Lordship. This is the impune order, Your Lordship. Page
So,
55.
so what are you praying for now?
I'm praying for the quashing of this order, Your Lordship. And to pursue my pension paper, Your Lordship. They are not giving me the pension money also.
When did you retire?
On 2024, 29 to 2024, Your Lordship. Your Lordship will find, Your Lordship, relieving order, Your Lordship.
Where is your retirement?
Your Lordship, kindly see page number 43, Your Lordship.
Hmm.
Office order, Your Lordship. I was relieved from the department on 29 to 2024. Page number 43 and except 4.
You retired as what?
As assistant, work charge assistant operator. Your Lordship.
Your post has not been mentioned. Please write hard, Mr.
Iraq Bangla.
Irabam. Learned counsel for the petitioner who submits that the petitioner retired as a work charge
Assistant operator.
assistant operator from the office of the assistant engineer bracket E Naharlagun Electrical Division -Roman 1 Department of Power on 29/2/2024, but he has not been given his pension on account of the insistence of the respondent authorities asking him to deposit an amount of rupees 464,348 on account of excess withdrawal by him. So the learned counsel submits that the excess withdrawal has purportedly happened on account of wrong fixation of his pay, and for which, the petitioner was not responsible in any manner. Stop. The learned counsel submits that the office order dated
There is no order, Your Lordship.
nil
Nil.
bracket annexure Roman 8 should therefore be set aside, and the respondent authorities directed to pay the pension, process the pension payment of the petitioner. Next, para in view of above, issue notice, motion returnable by 4 weeks. Ms. R. Basar, learned government advocate, accepts notice on behalf of.
One.
Hmm?
1 and 2.
1,
1 and 2.
1 and 2. While Mr. L. Perme, learned standing counsel, Power Department, accepts notice on behalf of respondent numbers 3 and 4. Notice is therefore complete. Petitioner to furnish extra copies within 2 days.
Lordship, I have an interim prayer. Interim prayer to stay this impune order and tell part of the department to process my pension matter.
You have any citation?
Your Lordship, there is a ruling judgment of Rafiq Masih. I remember the case, Your Lordship. I have quoted some of the.
You only remember. You don't want to produce.
No, you also I didn't come with the citation, but I still remember, Your Lordship. There was Rafiq Masih case, Your Lordship, 2014, and I guess.
You have not written that in your writ petition.
No, Your Lordship, but I have cited some. I quoted the.
Hmm?
in paragraph 14, Your Lordship, Honorable, that when low rank employee is paid a scale of pay which employee is not entitled to, however, by wrong miscalculation, such payment will be made for no fault of such pensioner, the said and shall not be recovered by the employer. Page number 21, last line, Your Lordship. These are the judgment, Your Lordship.
No, that
Not exactly mentioned. this.
citation is not there, na?
On the next day, Your Lordship, I will come with my ruling here.
No, you find out and give now only.
Right now.
Yes,
Your-
find it out from the library and give it to the PS.
Yes, Your Lordship.
Okay.
Yes.
Next para, having regard to the projection made by the petitioner and in view of the apex court decision in Rafiq Masi, he'll give you the citation, okay? It is here by the impugn order dated nil, and extra Roman 8 is hereby state. And the respondents are directed to process the pension papers of the petitioner.
Next order. Page 15 for SSC. 15 for SSC. 34.
List again.
Immediately after answering in the record.
On 8th of January.
May I pray PIP? I have a difficulty, my lord. I pray, my lord, some other day after PIP.
When? 19th?
Yes,
19th.
Yes, ma'am.
Give 19th. Next case, please.
Item number 4.
My please, Lordship.
Hmm.
My lord, in the year 2019, notification under section 10 of the Balipara Jumlane regulation for acquisition of land was carried out. And after the initial assessment and compensation having paid, the land was handed over in the month of January 2021.
Mm.
Then thereafter, my lord, in April 2021, the actual physical construction started. And after the physical construction has started, the BRO, they have slightly changed the alignment also. And during the constructions, so many damages were caused. Now we started objecting to those, and then we have represented there, saying that this was not contemplated during the initial assessment and payment of the compensation. So this arose a new course of action, my lord. Then, my lord, therefore, my lord, Deputy Commissioner on 11/10/2023, he had constituted a committee to verify and survey the damages that caused. And in that committee, the representative of the construction agency, that is the BRO, were added as member.
Tell you one thing, this is a road from Tatao to Mechuka.
Yes, my lord.
Land was acquired
Acquired?
under the Lara Act,
Yes. No, under Balipara Jumlane 1945 regulation,
1945 regulation.
1947 regulation, yes.
You have received the payment?
Not us, the others. That is one thing. And this lane were not part of that acquisition, but they have changed the alignment. And also due to the construction.
No, as per the alignment, which was planned, they have assessed the amount and paid the
Yes,
compensation.
that is
But later on, they have changed the alignment.
they have changed, later on they have changed the alignment.
And because of this change, your land is affected.
Affected. And also during the constructions, because of this dumping, they started dumping the entire materials. They caused huge damage
So
to our.
what have you done? You have submitted representation.
We have submitted representation. to the deputy commissioner.
And then verification was done.
Verification was done.
Then?
And verification, in that verification, the representative of the BRO were also there. And thereafter, this board, they have visited the site. They have prepared a report that these are the damages that were caused. And accordingly, the damages were submitted to the district authorities. The district authorities then had a series of meetings, and on 23/10/2024, they have finalized the amount. These are the amount, that is 4,29,93,097 rupees. Now that was sent to the deputy commissioner. The deputy commissioner forwarded to the government for approval. But then the director, he rejected that proposal, that forwarding, on the ground that this road has already been completed during 2019-20. And after 5 years of completion of the road, that you could not have given any additional assessment. Now, those grounds were factually incorrect. So therefore, the deputy commissioner has given a clarification to the director that no, this land acquisition started from 2019, completed only in 2021, and only in 2021 January we have handed over the land to the BRO, and the construction started in the month of April, and from May onwards the people has started raising issues that there is the change of alignment and then multiple damages that were being caused, and therefore we have constituted a committee for spot verification and assessment, and that has been done. So therefore, this proposal is not a belated proposal. And then, as suggested by the director, the deputy commissioner has forwarded this to the BRO also for their comment, and they have rejected this thing on the ground that there was no involvement of the district authorities. This is totally wrong, because that was initiated by the district authorities, and they have not said anything about their presence during the board meetings. And this report, this assessment, does not include the statutory provisions of components of solitium and interest as per the Lara Act 2023, 13.
But you are not the original beneficiaries in it.
Not in the original one.
Because of the original beneficiaries have no complaint.
No complaints. That first part is over, my lord. This is a new course of action.
Your complaint is that due to change of alignment, your land is also affected.
Subjected, and then
so you will be compensated.
Yes, during construction, because of the construction materials, they have caused a lot of damages to our properties. This is after this has been clarified by Deputy Commissioner also, that this issue has arisen after the construction activities had started.
Okay, show me that verification thing and the communication by the director.
Page 88, Annex 13 is the letter forwarding to the director, land management.
Forwarding what?
The additional compensation. Malad.
Where is it?
Page 88, starting the type copy is from 89. Malad.
No, where is the amount mentioned here?
Oh, Malad, this is
only a forwarding letter.
Yes, Malad. Page 70, Malad.
Why is this kept before page 88? What is enclosed in this letter at page 88?
Page 88 is this report, entire text of this report, Malad. This was
That's
this-
what, it should have been annexed after page 88.
Yes, but
Instead, you have annexed before 88.
this was forwarded to the Deputy Commissioner by the DLRSO. And this entire body has been sent to the, well, at page 65. Annexure 12. To the Deputy Commissioner, Siomi District Tato, submission of report on additional compensation bill and board proceeding of the stakeholders, such and such, my lord.
Now, who has constituted this board?
Deputy Commissioner, my lord.
By which order?
Page 44, my lord.
11/10/23.
Yes, 11 October 23,
Where is that?
page 44. Whereas a number of claims applications are received in this office from such and such owner, properties owner of Tato to Mechuka Road regarding claiming that their assets, properties are damaged during construction of road and some are left out in the first assessment report. Therefore, the following board members, officers and other stakeholders are hereby constituted for physical ground verification of left out damaged on Tato to Mechuka Road and prepare assessment report for payment compensation, such and such, my lord, chairman. And then at number 6, my lord, representative of 1443 BCC, Grave Mechuka. Now thereafter, my lord, page 45. A meeting was convened.
Ultimately,
Ultimately,
how much
after-
was assessed?
ultimately at page 47, annexure 5, these are the damaged or property found up to, my lord,
See, you are yet to receive any amount, get approved. Others have received the amount as per the regulation. Now you are claiming all this interest, solatium and all that. Unlike the other claim. What is that regulation called?
Balipara.
Balipara Tirap Sadhya Frontier Track Zoom Land Regulation,
Yes, my lord.
Amendment Act 2024.
This is an amendment to the mother regulation, my lord. By this, it is provided that the reasonable compensation, my lord, down bill clause 4, my lord, provided that the reasonable compensation so determined by the government shall not be less than the amount computed under the provisions of the Extant Land Acquisition Act for the time being in force. My lord, this means this 2013 Act.
But this is amendment only.
Amendment only.
It effective date from 14 August 24.
Yes.
So anyway, we'll issue notice.
Yes, issue notice.
What
This
will be
is
done?
this, my lord, please.
Heard Mr. T. Patil, learned counsel for the petitioners who submits that the petitioners are their respective landowners who have been affected by the construction of
Road from Tato to Mechuka.
road from Tato to Mechuka in the district of Siomi. He submits that land was acquired in the year 2019. and subsequently handed over to the BRO in the year 2021,
January 2021.
January 2021. Stop. However, without sticking to the alignment that was chalked out, the alignment for construction of the road had been modified, and for which reason the petitioners have been greatly affected by dumping of earth spoils, etc. On the basis of the complaint submitted by them, the Deputy Commissioner of Xiaomi constituted a fact-finding committee by order dated 11/10/2023. Of the committee, upon finding the claim of the petitioners to be genuine, the Deputy Commissioner made an assessment for payment of compensation to the petitioners to the tune of rupees 429,930,97.73. Despite the same, the amount has not been approved and sanctioned for payment to the petitioners for reasons which are not acceptable to the petitioners. And in terms of the relevant, in terms of the principles of law in regards to land acquisition, the petitioners having no alternative are therefore before this court. Next, para in view of above, issue notice of motion runnable by 4 weeks. Mr. M. Kato, London DSGI, accepts notice on behalf of
5 to 7, Madam.
numbers 5 to 7, while Miss
Tiwang Moment.
T. Wang Mo, Lanet, additional senior government advocate,
Government.
government advocate, accepts notice on behalf of respondent numbers 1 to 4. Notice is therefore complete. Petitioners to serve.
I have already served the extra copy.
Okay.
Just go.
Maybe.
No.
No, it's okay. It's there. I have already prepared it.
Petitioners to serve requisite extra copies of the writ petition to the respondents, if not already done. List again after 4 weeks.
Well, just an interim observation that the
What?
tendency should not be a bar if they decides to settle the matter, attend to the grievance of the petition.
That is always there.
One small observation, Malan.
Pendency is not a bar for the respondent authorities to settle the matter with the petitioners, if so advised.
Obliged, Malan.
Item number 5.
Mayor Lordship. Lordship, here the petitioner is aggrieved by the order by impugn order of Deputy Commissioner in an order where he has given the titleship owner of my land to the private respondent. Lord, this is a
He has not given.
Lordship in
Has
the
he given?
in impugn order he has said that may I take it?
Settle the matter.
Yes, but in that order he has given that may I take note, the impugn order page 21.
Prima facie, it is now assumed under proven until proven otherwise.
That the plot allegedly occupied by you belong to Mr. So and so.
Hmm.
This is the honor. I'm aggrieved
And
only
both
with
of you are hereby directed to settle the issue by lawful means
without restoring to aggression and
violence.
no, no, only on this, on basis of this, the private respondent is now coming and claiming that Lordship on the basis of this order.
Go before a civil court.
Lordship, I'll go before that, because if this matter is certain, I'll go to the civil court, because Lordship, I have to prove since the land is with me since the years 2012, Lordship.
So you need an order of the court to go to civil court.
No, Lordship, that is always there. Lordship, my just, a small prayer that till then, Lordship, the impugn order issued by the Deputy Commissioner be stayed, Lordship. In meanwhile, Lordship, I'll go to the civil court. That is my, because Lordship on this order, the prima facie is now assumed that the land belongs to Mr. So-and-so. Only on this basis, Lordship, the private respondent is claiming that the Deputy Commissioner has given the ownership, the title of ownership to him.
Mr. Tapin?
And Lordship, as per the section 12 of Arunachal Public Premises Eviction Act also, Lordship, once a notice is issued by the ESC, the order, if it's passed by ESC, the appellate authority is Deputy Commissioner. Yes, Lordship, the notice has been issued by Deputy ESC. Again, the order has been passed by Deputy Commissioner. So in that way, Your Honor, I'm no way to go, Lordship. The appellate authority is the Deputy Commissioner. But here the impugn order has been passed by the Deputy Commissioner himself, Lordship. And in this, Your Honor, entire petition also have stated no notice was ever issued to me, Lordship.
Lordship has already observed, Lordship. Yeah, Lordship, they have been directed to settle it through lawful means, Lordship. The forum is available, civil court and all, Lordship. And so far, second leg of submission is concerned, Lordship. This is not proceeding under Lordship Eviction Act of 2010, Lordship. This is just because complaint was lodged, then Deputy Commissioner said you settle it through lawful means. That's only the observation.
Correct. So that the law and order situation doesn't arise.
Yes, and it was already, this was issued on 29 May of 2025, Lordship. And the petitioner is coming now, Lordship. Instead of going to the Lordship civil court,
Lordship,
the petitioner could have gone to the
Go
civil
to the
court.
civil court, Mr. Counsel.
Lordship, I'll go to the civil court, but till then, Lordship, since Lordship, I'm employed under Indian Army, Lordship. I've been posted in Jammu and Kashmir, Lordship. That is the problem why I had filed this petition also lately, Lordship. Lordship, here therefore this line, Lordship. On this basis of this, Lordship, the private respondent is claiming the ownership.
So you go to the civil court and obtain an injunction then. That's all. It is not for this court to decide who is who.
Yes, Lordship, that I know, Lordship, but only with Lordship, since Lordship, even in my petition, Lordship, here Lordship, I have been issued notice by the ESC twice.
Please write. Heard Mr.
V. Jamo.
V. Jamo, learned counsel for the petitioner, who submits that the petitioner is being aggrieved with the order, with the, what is, this is not an order, with the communication dated 29/5/2025, issued by the Deputy Commissioner, East Siang District, Pasighat, is before this court. Stop. He submits that as per the said communication, the respondent number 5 lodged a complaint regarding complaint before the Deputy Commissioner alleging illegal occupation of his allotted plot by the petitioner. Stop. The Deputy Commissioner, without issuing any notice to the petitioner, came to the prima facie conclusion that the plot of land belongs to the respondent number 5. Unless otherwise proven, until proven otherwise. Stop. Further, the Deputy Commissioner has directed the parties to settle the issue by lawful means without resorting to violence. Stop. The learned counsel submits that in view of the said communication, the respondent number 5 is asserting his right over the plot of land, and the decision of the deputy commissioner clearly being in violations of the principles of natural justice. The same should be interfered with by this court. Now, upon perusal of the said communication, it is seen that the deputy commissioner has only rendered a prima facie opinion or assumption that the plot of land belongs to the respondent number 5, unless proven otherwise. To stop, the same by no means can be understood as a decision in favor of the respondent number 5. To stop, the communication also clearly provides that the parties are required to settle the matter by lawful means. And therefore, under the circumstances, it is open for them to approach a competent court of law to settle the dispute. To stop, this court, in exercise of its jurisdiction under Article 226, cannot entertain a dispute of such nature, since it would necessarily involve disputed questions of fact. Stop, such being the position, I find no reason to entertain this writ petition, and accordingly the same stands disposed of.
Lordship,
Leaving the parties to leave, the petitioner may approach the competent forum for mitigating his grievance if so advised.
Lordship, my small prayer is since only the paragraph which the deputy commissioner has said until proven this land belongs.
No, I have already made more observations than required, actually. You go to the, you go
Yes,
straight to
Lordship,
the, you go straight to the competent forum and get your orders. Next.
Item number 6.
Your Lordship, may I say?
Yes.
Your Lordship, the petitioners in this case are presently working as radiographers. The petitioners are working as radiographers. They are engaged as radiographers under the Department of Health Services.
I didn't get it. What graphers?
Radiographer. Radiographer.
Radiographers.
Yes, Your Lordship. Under the Department of Health Services.
Okay. Then?
And some of them have been working since 1993.
Hmm.
Now, Your Lordship, in the year 2014, many of the other cadres like lab technician, NM nurses, they were given salary enhancement. And the nature of our duty, Your Lordship, is that we have to be on 24/7 duty, plus we are exposed to radiation hazards. Now, when in 2014, the salary of other employees were enhanced, we are not given any kind of enhancement.
2014.
14. Yes, Your Lordship.
What happened in 2014?
The salary of other paramedical cadres like ANM.
No, was it a major revision of pay at that time?
Yes.
What is that? What is it called?
No, just pay enhancement, Your Lordship.
Pay enhancement.
Yes.
For?
Of the lab technician, pharmacist, and ANM nurses, ANM, GNM, and so on, Your Lordship.
Except for the radiographers?
Yes, Your Lordship.
Why was that?
That is known to the
Any representation you made?
Yes. So that is not the main issue, Your Lordship. Thereafter, when we are not given any kind of enhancement in 2014, we made various representations, and on being not addressed, then we came to this court by filing writ petition 553 of 2023.
Where is the order?
So, Your Lordship,
Have you annexed the order?
yes, yes.
Where is it? Page?
Your Lordship, that is again not the main issue here, Your Lordship.
Oh, then what is the issue?
The issue that we are being agreed by the, so, Your Lordship, after, when you came before this court for fair enhancement, then they finally enhance our payment
Okay,
in the year 2025, July.
okay.
That is on that order. I have annexed in page number 15, Your Lordship. This is the.
Hmm?
So in July 2025, and they finally enhanced our pay scale from grade pay of 2,400 to 2,800.
So now what do you want?
Now we are agreed that although they have enhanced our pay scale, we are claiming that we should be given equal pay from the year 2014. But they have said that we will be given enhanced pay only from 2025, Your Lordship. That is the main issue.
You want area enhancement?
Yes.
Well, from which date?
2014. From the date with the lab technician were given enhancement.
Show me one document that date 2014.
Yes, Your Lordship. Page 37, Your Lordship. That is of the lab technician.
He's right. Art, Mr.
Kitaja.
K.
Taja.
Taja. Learned counsel for the petitioners, who submits that the petitioners are radiographers and are aggrieved for non-enhancement of their pay with effect from the year
14.
With effect from October 2014.
Yes, Your Lordship.
Similar to their counterparts such as
Lab technician.
lab technicians, pharmacists, GMS or GNM?
GNM, General Nursing Midwives.
Then you have written GMS here. GNMS, etc. To stop, he submits that the petitioners were not given enhanced pay, and for which they had approached this court earlier. So person there too, although their pay has been enhanced, but it has been enhanced only with prospective effect from
2025.
2025.
July. From July 2025.
From July 2025. Stop. Now, by filing this writ petition, they seek for a direction for payment of their pay, enhanced pay, from October 2014, like the others. In view of above, issue notice of motion, turnable by 4 weeks. Ms.
K. Wangmo.
K. Wangmo, learned government advocate, accepts notice on behalf of
1, 2, 3,
respondent
6,
number
and 7.
1, 2, 3, 6, and 7.
Appearing on behalf of the standing council, Sabatagum.
Mr. N.
Titato.
T. Taco.
Titato.
T. Tato, learned counsel accepts notice on behalf of Mr. T. Tagum, learned standing counsel,
Health Department.
Health Department. Notice is therefore complete. Petitioners to serve requisite copies of the writ petition to the learned counsels appearing for the respondents within 3 days. List again after 4 weeks.
Item number 13.
Okay.
Basically, it become in process laws because it's about the disqualifications from Panchayat laws members, DPM laws.
Disqualification.
He was elected Panchayat member laws. He has been disqualified laws.
He was disqualified.
And the tenure is already over because now.
And he has challenged the disqualification. Which is that order? Impugn order?
43 laws.
43
laws. 43.
Passed by,
This is by the Deputy Commissioner also. He is the authority under Depiction Act.
what is he known as?
Lordship, this is the Arunachal Pradesh Local Authorities Prohibitions of Depiction Act 2003, Lordship.
Because of defection.
Because of
Who's the counsel for the petitioner?
on Galen, Mr. Galen is here, Lordship. Otherwise, it can be listed next week, Lordship.
Galen Talo.
Talo.
And it's listed for orders.
Orders, Lordship. And we have already filed our affidavit. Lordship.
When did you file?
It was filed on Lordship 7th by
You're not appealing for number 2?
Lordship 2 also I'm
2 also you're appearing.
appearing.
Then there's an office note saying that affidavit of opposition not yet filed on behalf of respondent number 2.
On behalf of 2 is not yet filed, Lordship.
Deputy Commissioner. You are appearing for Deputy Commissioner also?
Deputy Commissioner also, Lordship. I have filed for respondent number 1, Lordship.
1, Secretary Panchayat.
Panchayat, Lordship.
Anyway,
affidavit, because keeping aside all merits, Lordship, just I'm apprising this honor call, Lordship. Since new election has already come up, Lordship. The tenure is already over. So it become important. Otherwise, it may be listed next week, Lordship. In presence of council, Lordship.
no, the reason I was asking is because why it's listed for orders today?
Because affidavit is
Affidavit is not yet filed. You said you have filed it, but you have not filed for respondent number 2.
For 2, it has not been filed. For 1, Lordship, we have filed.
Election is coming, that we know. Monday is a polling day.
Lordship.
None appears for the petitioner when the matter is called. Mr. S. Learned Senior Government Advocate is present for the official respondents. So he submits that in view of the election, in view of the ensuing. No, he submits that in view of. He submits that the writ petition has become infructuous, as fresh election is due to take place on 15th of December 2025. Be that as it may, since the petitioner, counsel for the petition is absent, list the matter when?
Next week.
In the next week. Is that all?
Yes, Lordship.